Mr. Chairperson, sir, Article 262 of the Constitution of India provides for adjudication of interstate river waters disputes. May I just read out the head note of that Article 262 for the consideration of this House. It says adjudication of disputes relating to waters of interstate rivers or river valleys. I think the operative word in this article, Mr. Chairperson, sir, is interstate disputes. Since a new government has taken office, it is implicit in the philosophy of this constitutional article that before this bill was brought before this House, a fresh consultation with the states should have been undertaken, because all that Parliament is setting out to do is to put in place an amended adjudicatory mechanism in order to try and resolve disputes pertaining to water between the states. And the fact that the government has not chosen to do so, in my humble submission, is an assault on Indian federalism, which could have been avoided had the government carried out that consultation before bringing the amended bill. Now, what is the genesis of this entire bill, Mr. Chairperson, sir? The genesis of this entire bill is, over a period of 70 years, 4 out of the 9 tribunals which have been constituted to adjudicate interstate river water disputes have delivered their awards. 5 tribunals have not delivered their awards. In the statement of objects and reasons, a very specific reference has been made to the Ravi Vyas Tribunal, that it has not given an award over the past 33 years. Now, water is an issue which evokes passion, and therefore I will try and be dispassionate as possible. But if the Honorable Minister was to peruse the reason why the interim award of the Iradi Tribunal was never notified, and that would be available in the files of the Law Ministry if I'm correctly instructed, and the Law Minister is sitting here, is because there was an inherent legal infirmity in that award. And that inherent legal infirmity was that the 2 states, Haryana and Rajasthan, unfortunately were neither riparian states nor basin states. They were beneficiary states and therefore not covered in terms of Article 262(1), or for that matter, the Interstate Water Disputes Act of 1956. So therefore, the entire basis of bringing this bill in the first place, as stated in the statement of objects and reasons, is completely and absolutely flawed, in my respectful opinion. Now, Section 4, Subsection 2 of the original Act, which the government seeks to amend now, had said that the judges who will sit on the tribunal, or members of the tribunal, will be named by the Chief Justice of India and would be sitting judges of the Supreme Court and the High Court. I would come to this later as to why this provision was particularly inserted in the Act. But I would like to respectfully submit that if there has been a delay, even if it has been an inordinate delay in coming to a conclusion with respect to a particular dispute, it is not because the judges in question were not competent. These are the same judges who adjudicate 60 matters a day in a different setting. It is because matters pertaining to water are complex. And if anybody would be familiar with what transpired in Punjab between 1980 and 1995, he would conclude that water, unfortunately, played a very major role in those events which transpired in those 15 years. So therefore, to come to a very simplistic conclusion that because a certain tribunal or a certain set of tribunals, Mr. Chairperson, sir, I would request that the House be called to order. The House be called to order.
House is order. You can continue. House is...
Thank you, Mr. Chairperson, sir. So therefore, I was submitting that the reason why a particular tribunal has not been able to deliver an award is not because that particular tribunal was incompetent. It is because issues pertaining to water are increasingly complex. Now, let me come to the amendment bill. The amendment bill, on one hand, says that its raison d'etre or its rationale is to cut the time which is taken to resolve a particular dispute. And what this bill has done, it has added another layer to the dispute resolution mechanism. It proposes a two-tier structure in clause 4A, that first there will be a dispute resolution committee, and then under clause B, there will be the constitution of these mini tribunals. ये छोटे-छोटे tribunal बनेंगे एक बड़े tribunal के तहत. In my respectful submission, the reason why states request the central government in order to constitute a tribunal is because all consultations which inter se they carry out unfortunately have not come to a fruition. So rather than cutting the time with regard to dispute resolution, what is proposed in the amendment bill is only going to increase the time of that dispute resolution by adding another layer to already what is a complex mechanism. Now, Mr. Chairperson, sir, under the original act which is sought to be amended, Section 4, subsection 2 of the original act, Chief Justice of India, the Chief Justice of India was empowered to select the members of the tribunal. And there was a qualification that the members of the tribunal would be sitting judges of the Supreme Court or the High Court. And the reason why that clause was specifically inserted was because there had to be confidence that the people who are being selected to adjudicate an extremely sensitive and complex issue are neutral umpires. And the selection which is being carried out is also being carried out by somebody who is perceived to be neutral and above any partisan consideration, and that is why it was the Chief Justice of India who was empowered to select the chairperson and the members of the tribunal. Now, what does this act propose to replace it by? It proposes to replace it by a committee which will consist of the Prime Minister or somebody who's nominated by the Prime Minister. It would consist of the Minister of Jal Shakti. It would consist of the Minister in charge of the Ministry of Law and Justice. It would consist of the Chief Justice of India or a judge of the Supreme Court. But what I find missing is that this committee, unlike similar other committees which have been constituted in the past, does not have the leader of the opposition in the Raj Sabha or the leader of the single largest party in the Lok Sabha as its members. And I would want the minister to explain the exclusion of either the leader of the Raj Sabha, leader of the opposition in the Raj Sabha, or the leader of the single largest party in the Lok Sabha as to why they are not members of this election committee, which will pick up the chairperson, the vice chairperson, the 3 judicial members and the 3 expert members in this particular panel. Is it the intention? Is it the intention of the government, Mr. Chairperson, sir, to pack this particular tribunal by a favored set of people? Yes. And that is why there has been a deliberate omission that what is there in many other enactments and many other selection committees, that the leader of the opposition or the leader of the single largest party in the Lok Sabha would be a member of the selection committee, has been deliberately precluded from this. And number 2, what is extremely important is when you had a sitting judge of the Supreme Court or a sitting judge of a High Court either chairing the panel or heading or being a part of the panel, there was a perception that these people would be neutral arbiters of a dispute. Now, when you change the terms of selection and when you say that it can either be a sitting judge or a retired judge, I am afraid you're opening a Pandora's box of job seekers who will then primarily tend to do what in common parlance is called the command performance. And I do not think that this structure is going to inspire any confidence in the states which come before such adjudicatory panels, which are packed with people who unfortunately post-retirement may be looking for a sinecure. And I think this particular clause itself, or this qualification, defeats the entire object and the entire purpose of this amendment bill. Now, Mr. Chairperson, sir, if you look at clause 4C1, now the chairperson and the vice chairperson have been given a permanent tenure of 5 years or 70 years of age, whichever comes earlier. But the 3 judicial members and the 3 expert members would their terms would be according to the dispute they adjudicate. But under clause 12(2), if they are adjudicating more than one dispute, they can continue to be members of that tribunal or the respective tribunals. Now, I would like to ask myself that why make such a distinction? When you set up a tribunal, you do not look at it in terms of 5 years, 10 years, 15 years. You look at it in terms of 25, 50, 100 years. And what happens when you set up a specialized tribunal and you give people a permanent tenure of 5 years is that a body of jurisprudence develops. A body of experience evolves. And people, after going through a learning curve, are in a better position to adjudicate disputes. I cannot understand as to what is the logic that 2 people in the tribunal, the chairperson and the vice chairperson, will have a tenure of 5 years, while the other 3 judicial members or the other 3 expert members, will have a tenure on a case-by-case basis. Has this clause been deliberately inserted that if there is an inconvenient member who is not delivering according to a command performance, can be done away after a particular dispute has been adjudicated? I mean, this bill, for the lack of a better word, absolutely defies any logic altogether. Now, if you look at clause 6 of the bill, it says that the award given by the tribunal will not be published in the official gazette. There is no justification in the statement of objects and reasons as to why a particular award which has been given by a tribunal will not be notified in the official gazette. And Honorable Minister, sir, I would like to suggest that if you are really serious about resolving interstate water disputes, then perhaps you should consider a 3-tier hierarchy. A dispute settlement commission, which, as I earlier pointed out, may delay matters. Then you have the tribunal, and let an appeal lie to the Supreme Court. Rather than ousting the jurisdiction of the Supreme Court, let an appeal lie to the Supreme Court, because in any case, every matter will end up in the Supreme Court. And the reason why many tribunals have not been able to adjudicate and deliver awards is primarily because SLPs in that regard are pending in the Supreme Court. And I would now come to the final point. Clause 9 provides that the data which the government will collect with regard to a river basin, with regard to river flows, with regard to the various other aspects of a river basin are going to be outsourced to an outside agency. So therefore, one would like to ask as to, is the government not competent in being able to collect that data? And what would be the integrity of the data collected by an outsourced agency? Because if you were to go into the genesis of the problem with which each of these tribunals has encountered, is there is no agreement on baseline data. So therefore, when there is no agreement on baseline data, the adjudication process cannot proceed further. So I would very humbly like to submit, rather than outsourcing the collection of data and the collation of data and the analysis of data to some outside agency, and this doesn't even specify whether that would be a government agency or a private agency, it would be appropriate that if you want to have adjudication proceeding ahead, the baseline data collection should be with the government. And finally, may I just submit, Mr. Chairperson, sir, is that this bill seeks to go where angels fear to tread. I can only wish the government all the best.
Thank you.